Good morning, everyone. Thank you for joining us in our second Employment Law Forum, where we'll dive into more of a key proposed changes from recent Employment Rights Bill and the implications for your organisation. In this session, our expert, Donal Moon, Employment Law Advisor, will highlight changes to zero hours contracts, the fire and rehire practices, strengthened equality, diversity and anti-harassment laws, enhance flexible working and family-friendly rights, and other relevant employment law updates. Please use the Q&A feature to ask any questions as we explore these topics. These forums are about the new labour law initiatives, but if there are any other topics that are a priority for you, we want to know about them. So please let us focus and hopefully we'll be able to cover those in future forums. For your benefit, for those who didn't attend our first forum, Donal, please tell us a little bit about yourself.
Hi, Julia, and thank you very much. So certainly, hello, everyone. I'm Donal. I'm an employment law advisor with Moore Kingston Smith HR consultancy. So my role involves helping clients navigate the complexities of employment law. And I work with a team of talented HR consultants to do that and to help ensure that we provide clients with comprehensive advice. So I've been involved in employment law for around 17 years now, and with 12 of those being spent here at Moore Kingston Smith HR consultancy. And so really, when I think about why I got involved in employment law and why I continue to do it, my passion really lies in safeguarding clients, making sure they're well informed about their rights and also their obligations.
So what gave you this idea for this particular forum, Donal?
Yeah, so we've been doing a lot of updates for clients about the new changes that are coming in from Labour. And we've been doing big sessions trying to get everything across to people. But what I thought would be useful is to do sessions in bite-sized chunks. So it really gives people and clients the chance to raise any questions they want in a bit more depth than perhaps was otherwise possible with major updates.
Okay, thank you very much.
So that they can
Donal,
really get
before we
answers to the
begin, I
questions they
understand
want
there's been some significant
know.
updates since our last session. Are you able to run through those briefly for us?
Yeah, so there have been a few updates. So we now know the bill is continuing to pass through the legislative processes. Various consultations are open as we speak, and clients can find those by accessing gov.uk and looking for open consultations. Worth always feeding back on giving any feedback you want to in that regard. The next stage for the bill is the reporting stage at the House of Lords, and that's when we'll see either the House of Lords approving the bill and passing it back to Commons for the next stage, or more likely coming back with amendments for the House of Commons to consider. But one of the key changes that was announced, and I think we noted this before as a watch this space moment, was that the deadlines for tribunal claims were going to be extended, but we didn't know how long they would be extended to. We now know that most of the deadlines are being extended from 3 months to 6 months. And if just in case any haven't been announced yet, I suspect that future increases will follow that direction of travel from 3 to 6 months. I know we've had some queries about this as well, so I'm not going to cover this bit in depth, but there have been some updates about fire and rehire and 0 hours contracts. So I'll be covering those in more depth, I think, as we get onto the questions and answers from the audience.
Thank you. Our first topic is statutory sick pay. The new rules around statutory sick pay are quite confusing. Are you able to summarise them for us?
Yeah, no, I agree. They are quite confusing. I think perhaps the best way to look at it is that there are 3 key changes employers need to be aware of. So the first is that the 3-day waiting period is abolished. So employees get access to sick pay from day 1 of a period of sickness. 2, the lower earnings limit is being abolished. So that will pull more people into the orbit of those who can claim statutory sick pay. And a lower rate of statutory sick pay will be introduced for those earning below the current rate of SSP. So that's the 3 things employers need to be aware of. But I do appreciate very confusing.
Definitely. And how will it be calculated?
That's the even more confusing part, I think, unfortunately. Okay, so it's going to be the lower of the prescribed weekly rate. So that prescribed weekly rate is published on gov.uk, and it's updated every April each year. So the lower of that, and B, a percentage of the employee's actual earnings based on the statutory rates, which are, again, those are published in April each year. So the government is consulting about what the percentage should be. That consultation has now closed, and we imagine that an amendment to the Employment Rights Bill will be forthcoming to add that percentage in. So something
Fantastic.
we will keep people updated on that front.
Thank you. So next topic is 0 hours, and we've automatically got a question from our audience. So I'll just read it out to you. We use a lot of 0 hours and casual workers. Will this impact, what will the impact of this be on us as an employer?
Yeah, so yeah, a source of great worry for a lot of our clients at the moment. But yeah, so in terms of the impact on employers who use 0 hours or low hours workers, there are essentially 4 elements to this. So one, instead of an outright ban, as we thought it was going to be, there'll be a duty on employers to offer a guaranteed hours contract reflecting the hours that workers regularly work over a reference period. There'll be a duty on employers to give workers reasonable notice of shifts and reasonable notice of cancellation or changes to a shift. There'll be compensation for cancelled shifts or shifts changed or rearranged at short notice, and rights not to be subjected to detriments for things like accepting or rejecting a stable contract or shifts for specified reasons. So 4 elements that employers need to be aware of in that regard.
Thank you. Another question. Is there anything we can do now to limit our liabilities?
Yeah, again, we're getting asked that quite a lot, and we're saying the same thing to everybody. Audit your workforce by all means, and see who you think might be affected, so that you've got an idea of numbers and who this might apply to, and therefore liabilities. But other than that, we suggest not taking any action for now, for a couple of reasons, really. Firstly, this law won't be coming until 2026. And the other point to make is that a lot of the details that you'll need to know to be able to make the changes are still being firmed up and consulted about. So I think moving now might be jumping the gun, because you could take actions that you later regret, or which don't align with the new laws. So just to give you an example of the sorts of things that are in scope of these consultations, and still needs firmed up. So who is in scope? That's kind of important, I think. Obviously we know it's going to be workers, we know it's going to be low paid or casual workers, but we need to determine exactly who's in scope so that we can work out who to give these contracts to. The government's consulting about how it will apply to agency workers. Obviously, they want to ensure consistency of treatment with other types of 0 hours and casual workers. How to calculate the hours that should be offered. So again, that's kind of important if you're going to offer people new contracts. Those details are included. What would reasonable notice of a cancelled shift be, and what the compensation will be for notice of cancelled shifts. So yeah, I think it's only really once we know all of those details that you can really go into the weeds and assess your liabilities and then risks, and then make the necessary updates and start offering new contracts to people. But remember, the law doesn't come until 2026, so you may wish to hold fire until it actually comes in to start making the offers, but be ready to go by auditing and starting to prepare as much as you can, I think.
Thank you. We do have a question from our audience. Will this be circulated at the end of the session? Absolutely. This is a live recording, and so it'll be sent out to you automatically. Also, if there are any questions that we don't have time to answer here and now, we will address those directly to you back after the forum. So thank you for that question. So next topic, flexible working. Donal, we're getting quite a few questions regarding this. Okay, perhaps it might be helpful if you provide a brief explanation about the government's proposed changes.
Yeah, so yeah, there has been quite a big update in that regard. What we thought was going to happen, and what the government advertised was going to happen, was that flexible working would be made the default position. That hasn't happened. it's still going to be a right to request flexible working, not necessarily a right to receive it. What's happening is that, and the reasons for employers can reject requests remain the same, but it's made a whole lot more difficult for employers to reject requests. They'll only be able to do that if they can show that it's not reasonable to accommodate the request, and they have to explain in writing with reference to the reasons that they can reject a request why that's the case. So really what's happening is the burden of proof is moving in swinging harder towards the employer to be able to show that a request couldn't be reasonably accommodated before they reject it. And the new government also is intending to require employers, and this is quite an interesting development that's not been done before, to include flexible working options in job advertisements unless there's a clear reason why flexibility isn't possible for the role. So businesses really, it puts an onus on them also to assess the job roles that they have within their organization during the recruitment process and perhaps even before, and then provide transparency about what flexible working options are possible when advertising.
So kind of be contract ready, right?
Yeah, I think that's a really useful term to use. So I think, yeah, no, don't necessarily make the changes now, as we said before with the 0 hours contracts. There's still some details to fill in, but once we have those details, yeah, certainly be as ready to go as you can be.
Okay, fantastic. So let me think. COVID, dare I bring up the subject, and post-COVID, a lot of companies reposition themselves into a hybrid format. We ourselves are in that situation, which is works very, very well. Some organisations went totally remote, and obviously flexibility is key here, right?
Yeah, I think it is. And I think, yeah, you're right. A lot of companies, including our own, went sort of sort of a hybrid or in some cases, I've heard of businesses going fully remote during COVID. And it
Continues.
Yes, and it does make it harder, having done that, to then say to employees who are requesting flexible working, I'm sorry, we can't accommodate it, because the employer can always bring up, well, you did during COVID, or you did before, so why can't you now? And of course, some business models don't lend themselves to that. It was just done as an emergency, and so I think employers who are in that position where you think actually it doesn't work, but you did it during COVID, should probably make sure that they're in a position to argue against that type of argument, and be able to show strong reasoning why flexible working doesn't work within your model. But it does make it a lot harder for employers to deny flex working requests, I think.
Okay. Is there anything businesses can do now to prepare?
Yeah, so I think perhaps do an assessment of the business as a whole, and then drill down to your departments and then to individual teams and roles, and consider all the potential options you've got for flexible working that could work within your business at each level. And then if you decide, well, actually it wouldn't work for this part of the business or this role or for the business as a whole, document the reasons why with reference to the reasons that you can reject a request. And just perhaps this isn't really a legal point, but look at innovative solutions that could help you offer flexible working. So where you might be thinking, well, actually this doesn't work, think of different solutions such as technology that might be able to facilitate that arrangement. Review it after doing that analysis, possibly review and update your job adverts, again, not necessarily for now, but for when the law comes in. Be ready to go when the new law comes in with new job adverts containing the information about flexibility. Have a clear flexible working policy. I think that kind of goes without saying, but it's something that often gets lost in the shuffle. If you've got one but it's not been updated for a while, make sure it's clear and clear and in line with the law, and communicate it to your staff so that they know what their rights are in relation to flexible working. And last but not least, I think, and again, this may go without saying, but I'll put it in for completeness, train your managers.
Definitely. And in terms of reducing risk?
Yeah, so okay, there are some things that I suppose from experience, I'd say are invaluable. So firstly, don't prejudge any particular application. Yes, apply the rules consistently, but examine everything on a case-by-case basis. Each case is unique. As much as treatment must be consistent, each case is unique, and people have individual reasons why they wish to do flexible working, or individual arrangements which maybe don't fit arrangements that you've looked at before. Consider flexible working requests tied to family related leave, so paternity, maternity, shared parental, or disability related cases, with extra care. Tribunals apply a much tougher standard in those cases, and will expect the employer to essentially have looked at every possible permutation for flexible working. And if there's one that you've missed, even without thinking about it, that leaves it open to a tribunal to say, well, actually, you missed one. You didn't consider the request in line with the laws, and that burden, as we say, will get tougher still with the introduction of these new laws. So do consider those cases carefully and get legal advice, if you feel you need it, or if you're unsure about anything. Deal with requests swiftly, thoroughly, and in line with the statutory framework would be my next tip. And don't be tempted to deal with things informally. I've seen cases where clients have come a cropper, well, not clients as such, but I've seen cases where employers have come a cropper, trying to do the right thing and trying to be nice and deal with things informally, but in doing so they've slipped outside the statutory framework, a dispute's developed, and then it becomes the stuff of disputes. So whilst that may be tempting to do that and be nice, always follow the statutory procedure and document everything. That can be fundamental for a tribunal to understand your decision making, and how you considered a case.
Okay. Thank you. That was really thorough. Thank you, Donal. If I'm right, there are 8 reasons that you can reject flexible working request. Am I right?
Yeah, that's right. So we've got. I thought I might be asked that, so I've made a note of them. I made a note of them. So there's the burden of additional costs. Difficult to rely on that one on its own. You probably need one of the others as well to back it up, but it is one of the reasons. Inability to reorganize work amongst existing staff, inability to recruit additional staff, detrimental impact on quality, performance, or ability to meet customer demand. And that's 3 in 1 I've covered there, but a detrimental impact on those things. Insufficient work available for the times the employee wants to work, and planned structural changes to the employer's business. So those are the 8 reasons. So yeah, they are there, and they're pretty readily accessible. If you look at the ACAS website as well, if clients want to have a look at that, it'll list those points out neatly. But it's not always easy to. Every employer thinks that the reason they want to reject fits into those terms, but it can be a very technical legal question. So again, as always, seek advice if you're unsure.
Okay, we've got 2 questions from the audience that have come up simultaneously. So I'm going to ask the first one first. Hi, with increased flexible working, which may increase working from home, how is management control of employees to be carried out? We have a number of software options for installation on company devices that monitors the employee's work time and programs accessed. If this is rolled out in a company, do you think it amounts to a change of T's and C's, terms and conditions, or can it be a simple form to be used that an employee could sign instead?
Yeah, so so I think in a way I've covered some of those points in earlier questions, I think, but I think this is a really good question because it kind of ties it all together with a practical scenario. So I think the first thing is, does your contract allow for this type of monitoring? So the first port of call in these cases is always the contract of employment. Is monitoring allowed, and if so, to what extent? Then you look at, so if the type and extent of the monitoring you want to do is covered, then yes, you can do it, and inform your employees accordingly, using potentially the addendum that you've described. If the type and or extent isn't covered, yes, this would be a change of terms and conditions, and yes, you would then need to consult with the staff to get agreement to the change. Yes, you could just issue. Some clients choose to just issue an addendum and then consult with any objectors. Sometimes it might be said that it's best to err on the side of caution and consult with people anyway, because this is quite fundamental stuff that can be the stuff of disputes. So yeah, sensible, I think, to consult with people with a view to getting their agreement to the change.
Okay. Could you cover the contractual obligations an employer has re digital nomads? In particular, can an employer change the salary rate if an employee moves to a country with a lower rate of pay?
I get so digital nomads. So you got what you've got here is someone moving to a country at a low rate of pay. I suppose the question is which regime governs the employment relationship. Um, Now, generally speaking, in those cases, if you're staying on a UK contract, then the UK rules would continue to apply. But we usually advise clients in those cases to seek advice also from a local lawyer in whatever country the employee will be based, to make sure that whatever contractual terms and conditions you're giving them comply with local legal requirements. Also, if the situation is that you want them to work remotely for a UK company, but based on a local contract in whatever country, I think the answer would be pretty. Again, you would need to check with the local lawyer whether that sort of arrangement's acceptable. But I would say in those cases, if you're choosing for a different regime to be the one that applies, you would apply the relevant minimum rates in that particular country. But this can be a bit of a thorny issue as to whether those types of relationships are acceptable, and where the employee can be based on what regime they can be under. We usually would pull in our global mobility team to advise on that, because we've got experts in every country, and they'll tell you exactly what arrangement's suitable for whichever country you're using it in. So I guess it would be a case of, in the first instance, taking advice from a local specialist to make sure what sort of arrangements are acceptable, deciding which country's regime should apply to the contracts based upon the advice that you're given, and then if it's the local regime, then you would apply their rules. If it's the UK, then you would apply UK rules. Sorry, it's a bit of a
And
bit of a long answer there, but
yeah,
I think there's quite a lot of advice that needs to
a
be
lot of facets
taken.
to this
Yeah,
question,
there's a lot of
isn't
advice that
there?
needs to be taken to establish what type of relationship's acceptable, and then on the basis of the answer that you have, then you can make your decision about which regime applies, and therefore which statutory rates apply.
Look, if anyone's got any worries and concerns, please seek legal advice. Donal, you're available to assist any of our audience members should they require your services, right?
Yeah. No, yeah, certainly I'm happy to be a sounding board for anyone who needs help.
So next topic is hire and rehire. Will the government's restriction on hire and rehire eliminate our ability to renegotiate contracts?
No, it won't. It won't prevent you from doing it. You'll still be able to negotiate terms with employees, but the process has to involve meaningful consultation with the employees who are affected. And the emphasis has to be on trying to obtain agreement. So you'll also need to be able to show that the financial viability of your business depends on making the change that you want to make. And if you can't show that those things are true, any dismissal would be automatically unfair.
So automatically unfair, what do you mean by that?
Sorry, yeah, no, yeah, quite right. I forgot to explain that bit. So in many cases, you can dismissals will be potentially fair. So you can prove that they're fair, provided that certain things are true, and those are, conduct, capability, redundancies, statutory dismissals required by statute or some other substantial reason. Automatic unfair reasons for dismissals are ones that the law has specifically classified as being unfair. So you can't defend them, that they can't be potentially fair. They're just auto unfair for dismissals for that reason. So discrimination would be one of them. Dismissals for whistleblowing would be another. And this will be yet another once the law comes in. Fire and rehire at the moment fits into the category of either redundancy or some other substantial reason, depending on the reason that's being relied on by the employer. But it would no longer be the case when this new law comes in, automatically unfair as well, unless those two things can be shown to be true.
Okay. Another question. Are you ready? As an employer, we're looking at all the potential changes that could come our way. We're not looking to make any immediate redundancies. However, do I still need to consult with my staff collectively if I want to make any changes to their contracts?
Yeah, so you certainly would do. Yeah, and I think I know where this question might be coming from. But yeah, so if you're making a change for 20 or more employees at one workplace location, um, you might not be planning any redundancy. So you might be kind of shocked by the advice you receive that you need to consult, but actually you do, because you might not be planning redundancies, but that could be one of the end results, or if the employees fail to agree the changes you want to make. And for collective consultation purposes, that certainly is classified as a redundancy for employment law purposes. So yeah, you may need to collectively consult if you're planning that type of change for that many people.
And what happens if genuinely we cannot avoid changing our terms and conditions?
So yeah, so as I say, it's not a total ban as we originally thought it was going to be. Um, you can still consider firing and rehiring, but as long as you follow the right processes, so you consult genuinely in a genuine attempt to get agreement, and you're able to produce the evidence to show that the financial viability of your business depends on making this change. I think that those two things will be fundamental. So you can still do it, but there's a lot more hoops that you have to get to. It's a lot more risky than it used to be. Let's put it that way. But you'd need to prove, and also you'd need to prove that renegotiating the terms is essential, and that all other options had pretty much been eliminated before you went down that road.
Okay. And what risks would we face if we used fire and rehire practices after the law comes in?
Yeah, so it's going to be a lot more risky than it used to be. So I think the most obvious one that's screaming out at me is employment tribunal claims for constructive unfair dismissal, a number of other things, um, financial penalty, and the financial penalties and costs that go along with those, which can be quite substantial. But another one that's often overlooked is reputational damage. So, and particularly if fire and rehire became associated in government literature with what was called unscrupulous employers. So one being classed in that bracket isn't ideal for an employer.
And wasn't there an example of this?
Yes, there
Racking
was.
my brains.
I think I know the one you're thinking about. So that would be the P&O Ferries case.
That's it.
So
Yes.
it happened a couple of years ago, and it actually resulted in the ACAS code of practice that we have now, and probably in all this new legislation as well. It was essentially 800 employees who were dismissed by video. So again, not ideal in the first instance, and they were replaced with agency workers who were cheaper. They were offered, I believe, settlement agreements far in excess of what they get if they went to a tribunal. But there was a sit-down protest, and individuals were removed by security. But anyway, the upshot of it was plastered all over the press, and the CEO was called to the House of Commons to explain himself. So even though I think most of the employees may have ended up taking the agreements, we don't really know that. I don't suppose we ever will. But even so, the reputational damage was substantial. So yeah, it can land you in hot water, and they're not the only ones doing it. It's a good few high profile employers got stung by got roped into the bad publicity around it.
Okay, thank you. We've got another question. Sounds like some of these changes are effective 2025 and some in 2026. Is this correct?
Yeah, that's right. So we've got some consultations ongoing. We've got consultations ongoing on many of the aspects of the Employment Rights Bill. Some changes that the last government brought in are coming in this year. So neonatal leave and pay being one of them. We had, of course, the protection from sexual harassment law coming in last October, but then and the tips and gratuities, I believe, is now in, and again we'll have the rate increases, and the national insurance rate increases will be coming in. The ones that will be the majority of the materials contained in the Employment Rights Act, though, will be 2026, and really the government knows that employers will need time to prepare for this substantial change. I think there were 28 changes to employment law contained within that bill. So the government knows there'll be a lot of preparation to do, and a lot of consultation that will need to be had, because some of these changes are very, very complex and require a lot more thought than simply bringing them in and hoping for the best. They will need to be, all the details will need to be ironed out.
Another
But yeah,
question
absolutely
for
right.
you.
Yep.
Oh, okay, sorry, they're coming through thick and fast here. How does the government propose to reinforce or enforce the change to fire and rehire?
Well, that's a good question. So I think the primary mechanism will be the tribunal system, as always. So giving employees the right to the fact that they're making it automatically unfair to do this without having those particular hoops, covered. Is very important. I think there'll be this. I think the strengthened role of trade unions will undoubtedly play a part. Stronger trade unions equals stronger negotiating or more robust negotiations, and potentially less incentive for employers to kind of steamroller changes through without proper consultation for fear of industrial action. There'll be a new group grievance facility that ACAS will be bringing, that will be via ACAS, where employees can raise group grievances to ACAS. Now, ACAS, just in case anyone doesn't know what ACAS is, it's the government body that acts as a go-between to try and resolve employment disputes without recourse to litigation. But this will be an interesting expansion of their role into dealing with group grievances.
Okay,
and I think the last one again, I think is making it automatically unfair to do this without first having been able to prove certain things. I think so. Those four things I think will be the primary mechanism of enforcement in this case.
So, Diana, if I've got this right, the steps we can take to prepare for Labour's changes are audit current practices, enhance consultation processes, document necessity, and train managers.
Yeah, I think that's exactly. I think that's a fair summary. I think that's a fair summary of what we've got there. Yeah, and I think the only two things I would add in that regard as well is keep up to date with developments, because they're coming through thick and fast. So always make sure that you're keeping up to date and on top of things. So take advantage of all the free information that's out there. There's a lot of it about that you can kind of get yourself updated. And arm yourself with as much knowledge as possible. And I think also do get involved in consultations. As I said earlier, there's lots of consultations open on gov.uk. If you've got an opinion that's burning in your mind that you think, I really think that the government should consider something,
I think we just got a few technical issues here, so sorry about this, everybody. You're back with us.
Hello, apologies for that. I got kicked out unexpectedly there. So I was just at the point to say I think those ideas that you have for preparing for Labour's changes are really good ones. The two I was going to add, and I think I got halfway through one of them, was do get involved in government consultations. They're all available on gov.uk. And so worth looking into. If you've got something that's burning in your mind, I think it's worth government hearing this. They do listen. Whether they actually take on board your suggestions, we couldn't promise, but it's worth feeding back to them. I know that they do read them and review them, and quite often you'll see them react over. A good example of that perhaps is the 0 hours contracts. That was originally going to be a complete ban. But when they started speaking to people, they realized that some people quite like their 0 hours contracts. So the decision was made, I think, on that basis to shift away from that and make it a duty to offer rather than banning the contracts altogether. So I think that was the first point about consultation. And yeah, keeping yourself up to date, I think, is going to be key here, because these developments are really coming through thick and fast now. We're getting updates on this pretty regular at the moment, and things that we thought were going to be added or worked out in due course starting to be added to the bill and put into draft legislation.
Thank you, Donald, and thank you. And this just proves that this is live and this is what happens. So don't you worry. Our next topic is equality and anti-harassment laws. We do actually have a question from the audience, but I think we might cover it in and what we've got ahead here. So, Donal, one thing I know that you're personally receiving a lot of client inquiries is about the duty to prevent sexual harassment. And it looks like the new government intends to strengthen this duty even further. Are you able to explain what the government is doing?
Yeah, sure. So just by way of a quick primer, so from October last year, a new duty came in on employers to prevent sexual harassment in the workplace. So that's a proactive duty on employers to take reasonable steps to prevent sexual harassment. The last government had inserted third-party harassment provisions, making employers prevent any harassment by third parties. It got to the House of Lords, and that was removed, and that remained removed. So this law came in without those bits included. But that law is now in, but the government's looking to strengthen that even more. So firstly, it's going to change the duties to take reasonable steps by adding the word all before reasonable steps. So the employer now has to take all reasonable steps to prevent sexual harassment in the workplace. Whilst that might not sound like much, it actually is. It's putting a much tougher standard on employers when defending sexual harassment claims. Essentially, it can allow our tribunal, a bit like the flexible working example we discussed earlier, it would allow a tribunal to look through all the potential examples of things that you could have done as an employer to prevent sexual harassment, and say, actually, you forgot one, so therefore you're liable because you haven't taken all reasonable steps. Some critics have said that it amounts to what they call a strict liability, so pretty much you're guilty unless you prove otherwise. Perhaps a little bit of hyperbole, but yeah, it is certainly making a much tougher standard for employers to follow. They're reinserting the third-party harassment provisions, which I heard. Now, well, once that goes to the House of Lords, I don't know whether that gets overturned again. The last time the House of Lords, I believe, was concerned about the law becoming overburdensome on business. Whether they'll have a similar concern this time, I couldn't say. But what that does essentially is place that duty to prevent third-party harassment on statutory footing, so giving it much more legal force. And also removing the requirement for the harassment to have taken place on at least 2 occasions before you can bring a claim. So that's quite important. It can happen only once. Sexual harassment will be added to the list of issues that employees can whistleblow about. So there's a list of things at the moment. This will be added to it. So that adds an additional layer of protection for those who raise complaints of sexual harassment in the workplace, that they can't be subjected to a detriment because they do it, and they can't be dismissed because they do it. So much more protection for employees and workers in that regard. And then a new obligation on bigger employers, that's employers with over 250 employees, to develop and publish equality action plans. And part of that will include reporting on the steps they're taking to prevent sexual harassment. So that's quite an important step. They're not required to do anything like that at the moment, but they will be when this law comes in. And the government's adapting its gender pay gap reporting portal at the moment to allow this to happen, to report those types of things as well. And so I think what will probably happen is employers will probably have to publish these reports or these action plans on their website and then upload them to the portal, a bit like they do with privacy notices and gender pay gap reports at the moment, the modern slavery statements. What I do think, it all sounds like quite a lot to take in for employers, so I appreciate that. But what I do think is kind of helpful is that the government have said that they want to introduce a new section into the Act, which says that regulations will set out what reasonable steps would be. And if that's followed, then what we may end up with, and what I hope we will end up with, because it will be much easier for employers, will be a checklist of things they can look at and tick off essentially once they've taken the steps, and then be able to show to a tribunal we took all the steps set out in this section. that'll be a lot. I mean, again, no one likes checklists, but it's better than having to kind of second guess or to guess what reasonable steps might be, and then falling afoul through no fault of your own. So yeah, it may be that we end up with a definitive list that employers can use as a checklist.
And kind of, can you cover what that checklist could be in sort of like bullet points? Just give us an idea.
Yeah. So well, yeah. So what we know. So I can tell you which ones have come out so far. So we've got carrying out assessments, which we think will be pretty much risk assessments. Publishing plans or policies, which I think will be a sexual harassment policy and action plans. Steps relating to the reporting of sexual harassment. So I think that will be having a clear policy that sets out what you need to do if you experience or witness sexual harassment. Steps relating to handling a complaint. So here's how your complaint will be handled, and training for managers on how to handle complaints that are received. And finally, I think there'll also be a focus on neurodiversity. I think we can expect that to be set out somewhere in this checklist. I know that doesn't relate to sexual harassment, but it may relate to the third-party harassment provisions.
So we understand preventing harassment in the workplace is a really critical topic, and we're currently in the process of organising workshops aimed at helping our clients navigate this important area. Our goal is to equip them with the knowledge and tools necessary to effectively handle such cases and situations as they arise. Should you have any questions regarding further details, please do not hesitate to reach out to either Donal or myself. Now, our next question is based on what do the new equality action plans actually entail?
Yeah, so this is going to be, I think I mentioned this already, but just for completeness, it's for employers, big employers, so employers with 250 employees or more. At least that's at the moment. Things can change as the bill goes forward, but at the moment it's for big employers, 250 or more. The plans have to be published, so I'm guessing that will be the employer's website, and reported via the government's online portal, and they're adapting the gender pay gap portal to enable that to happen. And again, so what exactly will be in these plans is open to discussion, and the government will be talking to the Equality and Human Rights Commission about that and firming up the details. But we do know at a very, very high level at the moment, and again, we'll keep our clients updated as more plans are published and more details emerge. But we know that the plans will include steps taken to prevent sexual harassment. Advance what employers are doing to advance equality between male and female employees, what they're doing to address the gender pay gap. So a very, very different approach to the last government, which is you have to report what your pay gap is, and you can give a narrative, but you don't actually have to show that you're doing anything about it. Now you're expected to show exactly what you're doing about it. So a much more proactive requirement expected of employers, and plans for supporting employees going through the menopause. Now, for smaller employers, there won't be any such requirement in relation to menopause, but the government will be issuing guidance to help smaller employers support employees going through the menopause.
Okay, Donal, we've got quite a few questions that we will try and answer now based on what we've already covered. So one of our audience members has said, did you say that this is applicable to employers with more than 250 staff?
Yes. So if this is the equality action plans, the requirements to publish those at the moment is for larger employers only, 250 or more employees. For smaller employers, I think the focus at the moment is going to be on producing guidance to help them comply with some of these things. But for the moment, it's 250 plus. That doesn't mean things can't change. It could be that the law is toughened up by the time it gets to a committee stage. Unlikely, but it could happen. But at the moment, that's the position. Yeah, it's 250 plus.
In a previous topic, we said about checklists. One of our audience members has asked, where do we find these checklists?
Is this for the so yeah, so if we, well, there is no checklist as such. The trouble is most of it's due to be published in regulations that will follow. Some of it's emerging from regulations that are following or amendments to the act. But I think we'll have to wait and see where the regulations are actually what the regulations say when they're actually published. And that probably won't happen anytime soon, I wouldn't think. The bill's got to get through all the committee stages first, and that's when the regulations usually start to be drafted. One thing that might help, I think, at the moment, so especially if we're looking back at the Equality Act, and steps to prevent sexual harassment, the new duty there, the Equality and Human Rights Commission has published an 8-step guide, and that can act as a starting point for a checklist. I suspect that's where the starting point will be, and then we look at the regulations to see what new things might be added to that. That would be my suspicion at that point. But yeah, certainly check out the Equality and Human Rights Commission's website, because that's got the guidance for really good guidance for employers, and an 8-step guide to help you comply.
Fantastic, thank you. Is the 9-month probation to workers effective now or in 2026?
2026. And we don't know whether it'll be 9 months yet. The government's currently consulting about that. We know that it prefers 9 months. But whether it ends up being 9 months, I don't know. It'll be subject to the consultation.
Thank you.
It does sound like a hell of a long time for a probationary period, doesn't it? But I suppose it acts in the employer's interest, because they've got 9 months to test whether someone's suitable. So it's a bit better than saying you've only got 3 months and then you're stuck with the employee with a full unfair dismissal rights, I think. So I suppose look at it that way. But yeah, that's what the government favours 9 months, but it's consulting about that. So that's I suppose we'll have to wait and see what happens. But it probably will be 9 months, but we'll keep a watch for developments.
Okay, here we go. We utilise remote workers from a country in the Far East. We have individual contracts for them. And as far as we are aware, there are no issues relating to employment law in the UK. Is this correct? And are there any safeguards that we should think about?
So we've got, so you've got an entity in the UK, but you use Far Eastern employees.
Yeah, shall I repeat it just one more time, just in case?
Please.
We utilise remote workers from a country in the Far East. So
yep.
You're right. We have individual contracts with them. And as far as we're aware, there are no issues relating to employment law in the UK. Is this correct? Or are there any safeguards we should think about?
It's difficult to advise in depth, I think, without seeing things like contracts and hearing a lot more about the relationship. I think I can give a little bit of an overview of how that might be approached. So if you're looking at which jurisdiction applies in arrangements like that, the primary factor tribunals and courts will look at is location. So that would suggest that this is the Far East location you're hiring the workers in. However, what the courts will then go on to examine is whether there's anything to override that. And what can override it is a close connection to the UK. And then you start looking at things like how much control the UK entity has over the person. Who do they report into? So there's lots of different things about how the relationship works in practice. And based upon the answer to all of those questions, a court would make a decision as to which jurisdiction applies. So very difficult to. So the answer is maybe, but it's a risky area, and I think you probably need advice from a local lawyer in the country that you're hiring the individuals, and also a UK based employment lawyer, and then kind of both to consider things in the round and make a decision as to what level of risk there is. It's not an easy question to answer, so I apologise I'm not able to give something more definitive there, but cross-border issues can be quite tricky.
Again, this individual could reach out to you directly to go through
Yeah,
a bit more detail. I think that'd probably be better.
Happy to take that offline if the audience member would like.
Okay, another question for you, Donal. When will a new employment contract template for new employees need to be in place by to ensure new laws are in place? I'll read that again. When will a new employment contract template for new employees need to be in place to ensure new laws are in place?
I think given that the laws won't be coming in until 2026, I would say for the majority of changes in the Employment Rights Bill, you would have your contracts updated in 2026 to account for them. And even if the changes are, because I think the unfair dismissal ones certainly are August 2026. So you could have, I suppose, a separate contract ready to go, but not issue until the actual law comes in. Danger of moving too early, of course, is that you've put in presumably a probationary period and all the new rules, and you might not want to do that until the law is actually in. For changes that are coming in now, so ones that the last government brought in, and ones that might be implemented next year, I would say just make any updates as they come in as part of your annual contract renewal cycle, and react to any other developments as they occur by either issuing new contracts or addendums. But with the bulk of the changes from the Employment Rights Bill, I'd say 2026 would be the time to incorporate those changes.
I think we've answered a majority of the questions, even though some are coming through. So I know time is really precious to our audience, as well as yourself, Donal. But as I said previously, if there are any questions that we have not addressed that are live on the Q&A, we will come back to you personally. I just want to thank you once again from both Donal and myself for your time and participation in today's forum. Hope you found it of interest. If there are any topics that really sparked your interest or any further questions, please feel free to reach out to either Donal or myself. We're here to support you in any way we can. Over to you, Donal.
No, I'd like to echo what you said, Julia, and thank you for hosting today, and thanks to everybody for joining. And it was good to see so many questions being asked. It's good to know that there's engagement out there and people are really invested in knowing a lot. There's so many changes coming in that I think it's good that people are engaged with this and ready to see what they have to do to make changes. I think
that's awesome.
great.
Well, thank you so much, and have a great day, everybody. Take care. Be safe.